gotta leave your money behind you.
Hello, everyone, and welcome to Give Me Some Truth International Edition. I'm Sil Michelin here with Wagner Condon Financial Advisors, and I'm joined by Stan Farmer. How are you, Stan?
I'm doing great. Thanks, Sil.
All right, fantastic. I'm really excited today because we have a special guest joining us, Mishkin Santa from the Wolf Group. He is the head of international taxes over at the Wolf Group. And we have a really interesting topic, I think, today. Kind of a slightly different topic.
I'm excited.
You're excited because you're a former lawyer. That's right. I think you've described yourself as a recovering lawyer.
But I'm still excited.
You're still excited. Okay. But you're fully recovered otherwise, right?
Yes.
So good. So
it's been long enough.
So what we wanted to talk about today is just recent court cases that may impact U.S. expats and American taxpayers, right? Nobody on the podcast here is a practicing lawyer, so we don't want to get lost in the legal, nitty-gritty. But we did want to give our viewers a bit of an update on a few things that are going on and share some thoughts as to what the potential implications could be for Americans abroad.
Why don't we start by introducing Mishkin and letting them know a little bit more about what he does do.
Absolutely,
and how he
Mishkin.
works with
If we can
expats.
hear a little bit more about you, your firm, and how people can get in touch with you if needed. That would be fantastic. It would be a great way to kick us off.
Absolutely. So first off, thank you so much for letting me join this podcast today. It's a very interesting topic, very relevant topic. A little bit about the Wolf Group and myself. So the Wolf Group, we're actually celebrating our 40th anniversary this year, believe it or not. We're super excited to have our 40th anniversary party this October. We are located in Fairfax, Virginia, so just, a little bit west of DC. And for 40 years, our biggest clients have always been the international organizations and diplomats in the DC area. So the big three are going to be World Bank, IMF, IDB, and their employees. We also work a lot with the United Nations and various other international organizations. And then people that are here on diplomatic visas, the A1, A2 visa, they're coming from a foreign country and serving in an embassy or consulate. That's kind of always been the baseline of the Wolf Group as a company. The company kind of changed a little bit back in, I would say, the late 2000s. What happens is in the late 2000s, the IRS and Treasury Department initiated what's called the Offshore Voluntary Disclosure Program, where the Treasury Department basically went into Switzerland based off of the intel provided by Bradley Birkenfeld and investigated a lot of the big Swiss banks, so Credit Suisse, UBS, a lot of those, banks. And we're looking to basically prosecute high net worth individuals, U.S. high net worth individuals that have been hiding foreign financial assets and income and not reporting that to the Internal Revenue Service and paying their fair share of tax. And so the Wolf Group was asked to heavily participate in representing a lot of clients from a tax reporting and accounting perspective during the Offshore Voluntary Disclosure Program. And by doing so, we did a lot of work related to controlled foreign corporation reporting, foreign partnership reporting, PFIC reporting, which is a big deal for a lot of those Swiss banks and Swiss brokerage firms. We can talk more about that here in a little bit. Foreign financial asset reporting, the FBAR, the Form 8938, things like that. And really became a jack of all trades in regards to, any type of foreign financial asset or international informational return that's required for a U.S. individual taxpayer or small business operating offshore. And from there, that's where our practice has really morphed into some smaller subsets. So, analysis and reporting of foreign trusts, foreign pensions, foreign life insurance, foreign digital assets or cryptocurrency, things like that. We kind of stay abreast of, the hot topics that are currently trending with, expats living abroad or U.S. folks that have, foreign ties. I myself am an attorney by trade, although I don't practice law because I'm one of the owners of the Wolf Group. I mostly represent an accounting fashion now, so I wear my accounting hat, tax preparation hat. Formerly with chief counsel of the IRS, and then went into private practice for several years. Worked for several years in Zurich, Switzerland, where I helped a lot of folks get back in compliance during the Offshore Voluntary Disclosure program. Came to work with the Wolf Group in 2016 and was made an equity partner in 2018. I am now one of the majority owners of the Wolf Group, and again, very happy to be here to discuss the topics that we have today.
Thanks, Mishkin. That was great.
Awesome. And yeah, the way this idea for a podcast came about is, we were having a call with you with the rest of the team, and one thing that you just happened to mention was that you were very focused at the moment on these few court cases that were happening, and you were even taking action as it relates to changes in the way that you handle some tax compliance related issues for clients. And look, this whole topic of offshore tax compliance, U.S. expat taxation, things related to FATCA, they're always subject to a variety, more or less, of different court proceedings, and we don't always keep up with them because oftentimes it's it takes years to unfold. It's pretty hypothetical. It doesn't apply directly to our clients. But in this particular case, I think there are things happening in the background in legal circles that may have direct implications for U.S. expats in particular. So, what are some of the court cases that you and your team have been keeping a close eye on over the last few months?
The biggest one right now is the Farhi case. That's the FARHY case. And that case is fairly massive because what it did is it basically took the ability for the IRS to give penalties for certain forms. There's the form 5471 and 5472. In particular, the 5471 is when a U.S. taxpayer has an interest in a foreign corporation. They have to file that form. And actually, I was talking to a client earlier today about that. That form is the same form that Amazon files, Google files. There's no distinction between Amazon and Google and, say, an individual that runs a controlled foreign corporation, a small business, basically. Let's say it does, $5 or $6 million in revenue, or even less than that. There's no difference between that taxpayer and Amazon and Google as far as pretty much what they're required to file at a very basic level. And if you fail to file that form, which is due on an annual basis to report your books and records, your income, calculate the GILTI tax, which is the Form 8992, the IRS can and does regularly issue $10,000 penalties for failing to file or failing to file an incomplete form. And that case basically was an awesome win for taxpayers because it said the IRS has no authority to really issue those penalties. For them to issue those penalties, they actually have to reach out to the Justice Department, basically have a case brought against the taxpayer, and then have the Justice Department basically sign off on issuing the $10,000 penalty, which they're never going to do. And so that's a huge kind of win right now for people that may not have been filing the Form 5471 or the Form 8992 or some of the related forms. I think for the time being, you have a temporary window to perhaps style a different path to compliance than the usual routes, which are streamlined filing, delinquent international informational reporting. Those are the general IRS amnesty programs that a lot of people are using. You may now have a less intrusive option that you can use to kind of come back in compliance because the teeth has been taken out of the ability for the IRS to issue those penalties. Prior to that, though, on December 6th of 2022, the IRS for the first time published an update to the Internal Revenue Manual, basically saying that for those same forms, they were also now going to allow what's called a first-time penalty abatement. So that's another thing that you can kind of push on, where you can say, like, look, not only do we have the Farhi case that basically takes your ability to penalize us off the table, but if you did penalize us, at least for that first year, let's say you're doing 3-year filing, I get a pass anyway if I have a good filing history. So there's a whole different route that you can take on some of these things where you can mitigate penalties. If you're in the midst of an active audit too, I've seen several attorneys use that case proactively to kind of close out the audit and win the case for the taxpayer. So some really, really cool stuff that's been happening there.
That's good to hear because, and this comes up quite a lot. And you're right. It's a bit ridiculous that a small entrepreneur, even in some cases, someone who's more or less, self-employed, would be subject to the same kind of compliance burden as a large corporation. But so this case could be of interest to people who are in a situation where, maybe they run a small business, they moved abroad, they incorporated an entity overseas, and were not always aware of all the forms and the filing requirements that they had. And now perhaps there's a quicker and easier path to getting back into compliance. So that's a topic that actually comes up a lot. And oftentimes people, they don't mean to hide anything. It's just, it's difficult enough for professionals to keep up with all the tax compliance requirements. So imagine for people who have other things going on.
It's a tremendous amount of information they're asking for on that form. Like I said, it's not like it's a light form. I mean, just imagine on an annual basis, you're having to fill out 30, 40, 50 pages of like a mini foreign corporate form inside your individual form with tie-in forms that also have $10,000 penalties. I mean, it's not a matter of if you're going to get a $10,000 penalty, it's when, even with a really good accountant, the odds of you slipping up on one of the 3 or 4 forms that kind of all tie in together are, just increase every single year you have that filing. And so it makes it's kind of like almost like anti-business, right? Where it's saying, look, we're not going to support our small business offshore businesses that are run by U.S. taxpayers, U.S. citizens. We're making it so difficult for them to do this stuff that it's basically not worth your time or effort to run a small business offshore. And if you do, you have to take painstaking efforts to make sure that you choose the right type of entity, you make the right type of election, typically called a disregarded entity election, which can only be made for certain foreign entities and has to be made typically within 75 days of opening up the foreign business. And, I can tell you personally from being, working and being offshore, sometimes when you get over there, you completely forget about the U.S. time clock and the U.S. rules. And that 75 days it marches by very quickly. So a lot of people get in this danger zone very, very quickly. And so this is a big win for a lot of those folks. And I'm hopeful that a lot of those folks will see this as an opportunity to, come back in compliance now, maybe, do some good planning and get themselves into a very efficient filing standpoint from both the U.S. and the foreign jurisdiction.
Interesting. Michigan, I'm just wondering, obviously I haven't looked at this case or read the court's opinion, but I'm wondering, is there precedential value here perhaps that might support arguments against penalties for the failure to file other IRS forms in a timely manner?
Unfortunately, no. It's
really narrow.
The big one that I think everyone is waiting on, where the IRS just, that you can just, I'm telling you, it just jacks up their revenue by so much. There are going to be the penalties on forms 3520 and 3520A. I mean, they love to issue those penalties to people. I mean, and they make it virtually impossible to comply with the filing of that form. So that form is typically used to file for a foreign grantor trust, a foreign non-grantor trust, a foreign pension, which can be classified as a foreign grantor trust, a foreign inheritance, a foreign gift. And you can't e-file that form. You have to mail it in, and it has to arrive at a special service center called the Ogden, Utah Service Center, which is, by the way, just between all of us on this podcast, is my least favorite IRS processing center. Their error rate, their manual entry error rate is about 21%. So that means, 1 out of every 5 files they pick up to enter into their system, they're entering it in incorrectly and maybe exposing people to penalties. I mean, we're talking not $10,000, hundreds of thousands of dollars of penalties improperly. And then you have to spend, $10,000, $20,000 just to fix a mistake that they made to begin with. But that's the big case that we're trying to really get the IRS to give some leeway on. And there's no first-time penalty abatement for those forms. We'd love to see someone really try to take the IRS to task on the penalties for that form. The Form 8865, the Form 8938 would be some other ones I'd love to see them take the task on. We had the Bittner case for the FBAR, which is the big one that most people should know about. That's the report of foreign bank accounts. That was a Supreme Court case, believe it or not, that was recently won by taxpayers. Prior to that, the IRS took a position, or at least some agents, that they could give a $10,000 penalty for each bank account you failed to report on the FBAR. So, for example, if I had an FBAR with 5 bank accounts, that was a $50,000 penalty, not a $10,000 penalty. And we saw some results where people were being assessed, millions of dollars of penalties and only have, $500,000 worth of actual net worth in those accounts. So there's a disproportionate amount of penalties related to the amounts that were being reported. So you had challenges, or you still have challenges under the Eighth Amendment, excessive fines, right? Which has not really ever been looked at. But now that that's been lost as a Supreme Court case, the Bittner case again, that's another big one where it kind of takes the bite out of the IRS, their ability to kind of say, hey, we can really ramp up these penalties and stack them, but rather dealing with, a more reasonable subset of penalties for penalty mitigation purposes.
So would the idea there be that it would be a $10,000 penalty per form effectively, as opposed to assessing a $10,000 penalty per account per year, where, the numbers can get pretty big pretty fast? If you had like 5 accounts and you failed, to file for several years, there's like $10,000 just keeps adding up. Here they would be saying it's a per form penalty, and so you're capped at $10,000. Is that that's the general idea?
And what would happen is the IRS would come in and say that. They'd say, look, we have the authority to do it by account. It's going to add up to this amount, but we'll just settle for whatever you have in the account today. And so, and there were several cases we were like, no, don't settle, take it to task. But I think, your taxpayers get wary of doing appeal after appeal after appeal and paying the legal fees. And, it's one of those things where someone actually went the distance. They went all 10 rounds like a Rocky boxing match. And you can see that, the Supreme Court agreed with the taxpayer there, and it's a great outcome. But I made some comments that this case shouldn't have to have gone to the Supreme Court, right? I mean, it's unreasonable to have the IRS be able to do that to begin with. To me, it's a no-brainer. It should be $10,000 per form, period. Why did we have to take that to the Supreme Court to litigate that? It's in my opinion, very, very inefficient use of resources and time, and just to get to a result that should have been that way to begin with. So very unfortunate that had to go that route, but great that outcome came about.
Yeah.
There's the Schwarzbaum case, which is pretty much settled and done, but that gives the IRS the ability to basically do what are called repatriation orders. So, for example, if you do end up with a bunch of civil liability penalties that have been reduced to judgment, but all of your assets are offshore, there's typically a whole process for the IRS to claim those assets if you don't pay them. And typically the way that's done is through a repatriation order. And Schwarzbaum has been fighting the ability of the United States government to do that, and pretty much lost on every front. And I believe the road is at the end the other day. I think they've come to an end on that one. But taxpayers always ask me, the secret question, Mish, what happens if I don't do anything? What can they really do to me? And now we know for a fact they can definitely do these repatriation orders. They can come in and say, look, we want your UBS account, we want your Credit Suisse account, we want your Bank Leumi account. We're going to work with that foreign country to claim your property, whatever it is, to satisfy our judgment. That's a big deal, because that kind of brings to life the reach of the United States government, some of these taxpayers. That in combination with the fact that they can also take that reduced judgment and give it to Interpol, which then allows them to issue, basically, it sounds like a movie almost, but a red card. So if you meander outside of your country, and you check into a hotel or something where you have to give them your passport, now they, basically can call someone to come pick you up. And if they have extradition rights, they can take you back to the United States for prosecution. So
you're on a midnight flight back to Leavenworth. Is that the way this works?
Yeah, probably. That's probably the way it works. But that's the danger zone, that the IRS is getting more sophisticated in their ability to not only track down the non-compliance of foreign financial asset and income reporting, but also the ability to enforce the rules, enforce judgments. They're not just hollow judgments. They do have there can be financial ramifications, from repatriation orders to Interpol red cards. There's also Internal Revenue Code 7345, which we've seen be very active recently. That's the FAST Act, which says that if you owe the IRS more than $50,000, you're going to send a notice to immigration and customs, and if you try to get a visa to come into the U.S. or you're trying to leave the U.S., they'll basically stop you from exiting or stop you from entering until you've dealt with the Internal Revenue Service on that liability and either gotten into a payment plan or reduced it to an amount less than $50,000. So, these things have all been things that have been in play for a very long time. The FAST Act has been around since 2015, but we're now seeing here in 2023 that there are coming to fruition, and they do have the ability to do a lot of things they've been wanting to do for a while.
All right, excellent. Any other cases that people should be aware of? We've touched on quite a few things already. So cases involving control of foreign corporations, very relevant to entrepreneurs. The case involving FBARs, I think relevant to a lot of expats.
Or were there any cases that just broke between the time that we first tried to get technically set up on this call and where we are now?
There's
on this
nothing
call?
really that's broke recently, but I would highlight for everyone on the podcast two kind of, not I would say older cases, but cases that are a little bit more aged. One is going to be the Hughes case. And in the Hughes case, the taxpayer basically forgot to fill out Schedule B Part 3. Schedule B Part 3 basically says, Question 7A says, do you have a foreign bank account? Question 7B says, if you do have a foreign bank account, did you file an FBAR? And most tax software, including the TurboTaxes and H&R Blocks, are default to say no. And so in the Hughes case, for 2 years, they basically said no, they didn't have those requirements, even though they did. And then for 2 years, they said they did. They filled it out correctly. Well, for the 2 years that they didn't fill it out, the IRS said you're willful. So the $10,000 penalty becomes a $100,000 penalty. And for the 2 years they did fill it out properly, they just got the $10,000 penalty. So the moral of that story, which I try to tell a lot of taxpayers, is you got to read your entire tax return. And I'm not saying just a cursory glance through it. I know a lot of people that don't read all the contents, and I get it. It's a big filing. It's a lot of words. It's a lot of calculations, but try to look through it if you can before you sign off on it. Make sure you know really what's in there. You are signing that under penalty of perjury. You can't defer that to anybody else. You can't say that, your tax guy did it the wrong way, and that really
TurboTax?
Yeah, or TurboTax didn't set me up correctly. I mean, those are not arguments that are going to win. And basically what happens is you get into a room with the IRS, they'll bring in 3 or 4 of those returns. They'll say, okay, is that your Schedule B Part 3? You'll say yes. And then they'll flip to the perjury section. They'll say, did you sign this under penalty of perjury? You have to say yes, and well, unless you take the Fifth Amendment. But pretty much it's yes. And then they'll bring them in the next tax return. And you can just, I've been in those audits, and you can see the blood draining out of people's faces when that occurs. It's not fun, and it definitely will get you into a lot of trouble. So make sure you read the contents of your return. If you are filing the FBAR, make sure you do answer those questions correctly. And there is an 8th question, question 8 on that Schedule B Part 3 about foreign trusts. So if you are filing the 3520 or the 3520A, make sure you answer that question correctly, because that can also be used against you.
That's a really good one, Mishkin. We have, oftentimes I think one of the bigger pitfalls that concerns me about clients is not necessarily the estate planning that they've done, but the estate planning that they're beneficiaries to when they go, when you're talking about people with families overseas. And the idea of a foreign trust that's not being correctly reported, or conversely, in a residence country, a U.S. trust that's not being correctly reported in a country like, say, France, right?
I can do cross-border estate planning, and there's not many of them. Every time I meet someone that's a good, say, cross-border U.S. France, cross-border U.S. Portugal, I'd really grill them, and I say, tell me about what you know about this stuff, and I really want to make sure that they're good at what they do, because that's a referral I want to keep in my back pocket. Those are hard to come by.
You and me both, Mishkin.
I'm sorry?
I said you and me both, Mishkin. The truly gifted foreign attorney that works with Americans and has some basic knowledge is not easy to find.
No, and even more so if they know the U.S. Foreign country estate tax treaties, which are very rare and hard to understand. That's critical to doing a lot of this planning. But you're right. I mean, you talk about so many different issues from foreign family members. You can have foreign trusts that can be grantor or non-grantor. You can have foreign estates, beneficial interests in foreign estates, foreign inheritance, foreign gifts. You can have attribution of foreign corporations. I mean, there is so much to unpack there that people, I think, don't even think about. They just think, oh, my, foreign cousin or my foreign uncle, eventually I may get, X, Y, or Z. But they may not even know that they have a current filing requirement for something within that, right there and then. So there's a lot of, analysis that needs to be looked at in that situation, just based off of our current rules.
Absolutely.
Absolutely.
The last case I do want to bring up, because it's a heavily used amnesty program, and what I'm referring to here is the IRS streamlined filing compliance procedures. Those have been around since 2014, and a lot of people use them. And I think a lot of people are starting to get the sense that this is just a easy pass program. You can just submit them, and that there's no karma. It'll never come back to bite you, no matter what you do on it. You don't need to be thorough or complete. And I think that you're misunderstanding the purpose of that program, and that the fact that the IRS is looking heavily at those submissions and that they should not be done lightly. You have the United States versus Gaitave, I believe is how you pronounce the name, but basically this individual submitted a false streamlined filing, and they basically audited it and found that it was false on several fronts, which they have the ability to do. I think a lot of people think they just read those non-willful statements and they hit a rubber stamp and then you're good to go. But if they can connect the dots and see that you haven't disclosed everything you need to disclose, and I would tell anyone doing that filing, it's your one-time get out of jail free card. If you're going to do it, make sure you get all of, do everything you need to do, clean up every little thing. But that individual, got a lot of scrutiny, had a significant trial. He had a really good defense team, which I actually know the firm that represented him, and got him off of the majority of the counts that were issued against him. But still, it's one of those things where I think we have to be very careful. I would advise a lot of practitioners that are maybe shotgunning in the streamlined filings, or not doing them appropriately, to take greater care with what you're doing there. Make sure to get your ducks in a row, get your questionnaires answered, get your foreign financial asset organizers completed, have attorneys do the non-willful statement, don't have the accountants do it. If the accountant did the original filing incorrectly, don't have them be the accountant that does the amended filings. I mean, there's a whole set of rules I think people need to be very careful about moving forward with any type of amnesty program filing. And so that's the last one. I probably inundated people with a lot of information.
Oh, that last one's super helpful, though. I mean, I know that they're not our clients, but I mean, I'm sure that there's a lot of people out there. Hopefully, they do reach out to us or to people like you, right? But there's a lot of people that might catch this podcast and and they're thinking about how do I get out of the mess that I'm in right now, and that kind of advice I think is incredibly valuable to those people out there that might be listening in and scared, right? And not sure how to start their process towards compliance. So
and what I would say is, the people that do a lot of those representations, in the end, it comes down to, you got to really ask the serious questions there. How many of these have you done? How many have been audited? How many have been questioned? How many times have you had to respond to a letter from the Streamline unit? How comfortable do you feel with certain topics? How many times have you done this form or that form? How well do you understand the rules? Do you know the Internal Revenue Code and the regulations related to those forms? I mean, really do your due diligence. Don't just, take someone's word. Oh yeah, we can do that. That's easy. I can do that form. Like, test their mettle as if you were hiring a contractor to redo your house, right? I mean, you're not just going to go with the first person you talk to. You're going to go out and get three bids, or hopefully you do that. I can tell you from personal experience, you should definitely do that. And the same is true for any tax professional that does, these types of amnesty programs. Interview 3 or 4 firms, really, test their mettle, make sure that they know what they're talking about, and you feel comfortable that they're going to be your pathfinder, throughout the entire situation, that they're just not going to do the work and then leave you high and dry. Make sure they're going to hold your hand to the very bitter end. So very, very critical.
Hopefully everyone listening and watching here got some useful bits of information, and certainly we are available for calls to discuss any of your specific circumstances. And with that, I think we are going to wrap it up. It's just been almost exactly half an hour, so we did pretty well here on timing, and we covered a lot of ground. So, Mishkin, really appreciate your time, and we look forward to being in touch. And we will now wrap it up. And thanks everyone for listening to another episode of Give Me Some Truth International.
Thank all of you.
Walkner Condon Financial Advisors is a registered investment advisor with the SEC. Registration with the SEC does not imply a certain level of skill or training. The opinions expressed by the participants of this podcast are their own and do not reflect the opinions of Walkner Condon Financial Advisors. All statements and opinions expressed are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for any individual. Listeners are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance. Thanks for listening, and for further information, please visit walknercondon.com.